and you stole a little bit of my thunder, but I'll allow it because we like you. Um, so, about the firm, very briefly, 23 attorneys, 8 including me that are board certified in this area of law, 1 board certified in construction. Start to finish, pretty much whatever you need. If you're an HOA, condo, or co-op, or you need a mediation in an HOA, condo, or co-op, we've got you covered. All right, so that's enough about the firm. Let me go ahead and I will share my screen, and this should do it. There we go. All right, so you've now got the information about us, about the class, and now we can actually start. So this is a little information about Chuck, and I'm not going to go through it because I'm not Chuck, and also because you will be getting these slides at the end of the presentation, like Jeff mentioned, as long as you fill out the information you need. So, starting the actual presentation, the policy of the United States is to provide, within constitutional limitations, which I will disagree with, but that's fine, for fair housing throughout the United States. The Department of Justice and HUD are jointly responsible for enforcing the Fair Housing Act. Now, when people are in your community saying, oh, that's a violation of the Americans with Disabilities Act, I'd say 99% of the time they're citing the wrong statute. That doesn't mean you should ignore them. But what it means is they might not be getting it right. What you should be doing anytime someone says you're in violation of one of these 2 statutes, the FHA, which is the Fair Housing Act, or the ADA, which is the Americans with Disabilities Act, call your attorney. Do not sit there and think you've got it under control unless your attorney has given you guidance on the exact same situation before. Now, we'll get into later, but the statutes are set up kind of like bankruptcy court, where it's intended to factually benefit the person that's raising these claims over the defendant or the respondent in one of these fair housing cases. So the goal is supposed to be to make sure that people have the same use of the property, even though they suffer from a disability. But the practical aspect is the association loses one of these fights, even if you win, because you don't get your fees and costs back, even if you win, unless you can prove that the person who raised the claim did so in bad faith, meaning they had zero basis whatsoever to actually claim discrimination. Now, keep in mind, discrimination just means that you violated the Fair Housing Act. So it doesn't mean that, and I know Chuck intended to go through the list. It doesn't mean that you were violating race, color, religion, sex, national origin, familial status. It could just be that they have a disability, they asked for an accommodation in literally any way, and you didn't immediately say yes. So I'm not saying any of this to scare any of the directors or the cams that are on with us today. We've got, I think, 170 plus people with us. That's fantastic. But all of you out there listening, I'm not trying to scare you off. What I'm trying to say is you have to be very careful with these issues and make sure that you actually consult with someone who knows what they're talking about. Now, keep in mind, we've got the Federal Fair Housing Act. These are the items that it prohibits, which is discrimination in housing, which includes a community association, condo, HOA, co-op, on the basis of one of these items. Florida also adds to that, talking about sexual orientation, age, marital status, gender identity, or expression. So those lists are a little bit different, but keep in mind, you can be subject to a claim under the federal act or the state act. So you can't violate either one, is really what we're saying here. Now, we talk about and Chuck, if you need to interrupt, if you had something you wanted to add, feel free to step in at any time. I know you're taking some of the later material, but you've got some valuable knowledge on this stuff as well. So I won't take offense like I usually do if you tell me
Yes,
for a minute.
we'll do. Yep.
All right. We talk about the difference between the U.S. Code and the Code of Federal Regulations. We mention this primarily because they're almost the same, the Fair Housing Act and the ADA. There are slight distinctions, but generally speaking, we're going to be talking about the U.S. Code here. This is just a matter of where do we actually find the laws we're talking about. It's not anything that you really need to know unless you want to do a deep dive of this stuff by yourself. And I will tell you that I've done research on Chat GPT. And unless I'm using my own custom GPT where I spoon feed it all of my personal case law that I've accumulated over the last 17 years, it comes up with really bad answers on these issues. So sometimes ChatGPT will give you good information. The Fair Housing Act is one where I've almost exclusively seen it get it wrong. So be very, very careful of using ChatGPT or Google Esquire. Okay, moving on. Regulations adopted by the Fair Housing Act. Again, we're talking about the CFR. These are just a list of the different discriminatory types of conduct under the Fair Housing Act. So we're not going to go through them in detail, but this is just so that you have this resource available. Here's what we're actually talking about. And I know I'm talking fast, and that's because we've got 82 slides to get through in an hour. So sorry. The Fair Housing Act prohibits housing providers from discriminating against housing applicants or residents. Keep in mind, this doesn't have to be someone who actually owns a lot or a unit in your community. It can be anyone who is trying to own a lot or reside in a lot, meaning prospective buyers and tenants can be subject or can subject you actually to a fair housing claim. Okay, because of their disability or the disability of anyone associated with them. What does this mean for practical purposes? It doesn't have to be the person with the disability that mentions the disability or makes a request for the disabled person to be able to come after you. Okay, it prohibits treating people with disabilities less favorably than others. That's one way to look at it. But it also talks about the next two things: reasonable modifications being allowed because a disabled person needs it to have full enjoyment of the premises, or reasonable accommodations of your rules to have an equal opportunity to use and enjoy that unit or that lot, whatever it may be. We'll talk about what each one of those is in a little bit more detail. But failing to provide either one of those when this person is entitled to one is the proper subject of one of these fair housing claims. Now, there are a couple exemptions to when you have to provide these reasonable modifications or reasonable accommodations. One is religion. Okay, you do not have to have in a religious organization, you can limit the sale, rental, or occupancy of a dwelling which the religious organization owns or operates to say only people of our religion or giving preference to people of that religion. That's all allowed. So you can say, well, we only allow Jewish people to live here, or we give preference towards Jewish people, unless membership in the religion is restricted because of another factor that is in and of itself a subject of the Fair Housing Act. So race, color, or national origin, or the property has a commercial purpose. Okay. Now, commercial purpose also applies to not-for-profit institutions. So keep in mind your HOA, even if it has a commercial purpose, that it'll be part of what we're talking about here with this exemption. The other thing is private clubs. The Fair Housing Act doesn't prohibit a private club from limiting rental or occupancy of lodgings it provides. Now, keep in mind, this isn't membership in the club. So when we're talking about your adjacent golf club, we're not talking about who can and can't be a member. We're talking about who can be lodged there, housing. If this is generally going to be seen, like I know my parents' community down in Boynton Beach has hotel rooms basically that are within the clubhouse that they rent out. Okay, that's what we're talking. Not whether you can be a member, not whether you can play golf or use the pool. We're talking about lodging. Okay, that's the exception, is the lodging itself. And it only applies as an exception when the lodging is not open to the public, meaning it's only open to the members. The lodging is incident to the club's primary purpose, meaning we're not talking about a hotel that also has a golf course. And the lodging is not for a commercial purpose. Okay, you're not renting it to only people that are doing business at the club. You're renting it to any member that wants to rent one. The FHA doesn't apply to discrimination based on 55 or older or 62 or older communities. That is an exception. Okay, it's an exemption to the Fair Housing Act. So when you've got your housing for older persons, that is allowed because of this written exemption. Okay, understand, if you didn't have this exemption in the actual Fair Housing Act, those 55 and over communities couldn't exist because that 55 and over restriction or the related restrictions would be a violation of the age limitations on the Fair Housing Act.
And let me interrupt you once,
Yeah.
Alan. I had an interesting client factual scenario regarding what we'll get into maybe a little bit later is HOPA, and that's the housing for older people, and that's 55 plus and 62 plus. And I want to make Yeah, I learned something valuable that it has nothing to do with the actual ownership of fee simple ownership of real property. And it has everything to do with residency. In other words, we represent an association that's a 55 plus, and a 43-year-old buyer wanted to buy a unit in there. And ultimately, we permitted this buyer to do that because he's permitted to under the United States Constitution. Any adult in America with obvious citizenship exceptions and other things can own in fee simple real estate. But what the difference is the residency in the community. And he was not planning to live there. Maybe he was buying it for his parents, for instance. So
Right.
that was what I wanted to provide.
No, good note. Thank you. I think this is probably one of the ones that people get hung up on the most. Controlled substances. The FHA doesn't prohibit conduct against someone because they've been convicted by a court of the illegal manufacture or distribution of a controlled substance. Now, that doesn't extend to the use of a controlled substance. So, being a crack addict is not a protected class, okay, or is a protected class. I'm sorry, we'll get to that later. Being accused or actually being convicted of basically manufacturing or selling controlled substances is not protected. So there's a big distinction between one and the other that really does come into play in practice. Not frequently, but it does happen. Um, Fair housing doesn't apply to certain real estate transactions where the owner doesn't own or have any interest in more than 3 single-family houses at any one time, or the house is sold or rented without the use of a real estate agent, blah, 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 blah. Okay, this is an oversimplification, which candidly, we have to put it in here for your information, but I don't like to get into it in detail because it would take about 15 minutes to explain it, and we just don't have that time. So here's a quick explanation of the interplay between the ADA and the Fair Housing Act. We're not going to go through it in detail, but it pretty much does the same things. It's just a matter of which one applies to what type of housing provider. Okay. 99% of the time, like I said earlier, we're looking at the Fair Housing Act. Occasionally, you might be looking at the ADA, but it's very rare. The terms handicapped and disability mean the exact same thing from a legal and practical standpoint. Don't look at those different terms as meaning something else. We use the term disability interchangeably, 90% of the time or more. That's the term we use. But the term handicap is technically what the Fair Housing Act says. Handicap means a physical or mental impairment which substantially limits one or more major life activities. Now, this is important because it's not just, well, I can't do everything perfectly. It's a substantially limiting factor in a major life activity. Okay. Not having your pinky finger may or may not create a disability for you. It depends what it creates a problem in your life to not be able to do. I don't like to use the term normally, but in reality, that's what we're saying here. Is that a major life activity? Generally speaking, probably not. Okay. You're probably not going to get an accommodation because you're missing your pinky finger or your pinky toe. But if missing your pinky toe means that you have balance issues that are diagnosed by a physician, that might be a major life activity that is impaired. So it's really, you can get into the nitty-gritty of it, or you can just say, okay, well, someone who is visibility impaired and uses a walking stick and goes like this all day to try and avoid bumping into things has an obvious disability or handicap. Now, the other thing that needs to be proven in order to have a handicap is a record of that impairment. That's where we get into the physician's note. And then being regarded as having that impairment is also good enough. So the fact that it's an obvious condition, again, the man or woman who walks around with the cane trying not to hit things, and yes, I know they're not going to lift it up that high. I'm just trying to make sure it's on camera. The term handicap does not include, as I mentioned, illegal use of or addiction to a controlled substance. Okay, physical or mental impairment is pretty much any mental disorder or condition. Cosmetic disfigurement is also included. We've got, like I said, your neurological, musculoskeletal, special sense organs, your breathing, speech, cardiovascular, all of these things. And literally, again, any mental issue. And when I say mental issue, I mean any diagnosed mental illness, whether it's self-imposed or otherwise, does not matter.
Autism, for instance, is a big
Right.
one these days.
Right. Autism is a big one, but frankly, anxiety is enough to have a
Yep.
disability. And it doesn't have to be the severe anxiety that is crippling. It can just be, well, this person's been diagnosed with anxiety. They need their emotional support animal, and you might have to allow that. We talk about major life activities. These are pretty self-explanatory and pretty obvious, I would hope. So I'm not going to read them out, but you'll have these slides to refer back to. Has a record of the impairment means that there's actually a classification of having one of these impairments. Again, a physician's note, or is regarded as having the impairment, which we mentioned earlier. There's actually something that doesn't substantially limit one or more major life activities, but that's treated by other people as being a limiting factor, meaning losing that pinky may not be a big deal to you. But if everyone else looks at you and says, oh my God, you're missing your pinky. Are you able to hold a baseball bat ever again? Can you play golf? Okay, well, now all of a sudden, even though it wasn't an impairment, now under the Fair Housing Act, it is actually considered an impairment, even though it doesn't actually limit anything because other people perceive it as being something that would limit your activities and your ability to perform those activities. And then it's also the attitudes of others towards the impairment or not having anyone else, but being treated as having an impairment. So again, if other people would look at your um, function, your factor, whatever you want to call it, and see that as a disability, it becomes one, regardless of whether it actually is or not, according to a physician. The association cannot ask whether someone has a disability. It's up to the person with the disability or someone on their behalf to actually mention it to you. You can't just come out and ask, do you have a disability? Unless someone asks for an accommodation. Okay, you can't ask if the person intending to reside there or if anyone associated with them has a disability. And you also can't ask about the nature or severity of a disability. Now, this can make it a little bit more difficult to determine whether someone's entitled to an accommodation or not. But that's what the physician's note is for. And, we can get into the details of what that physician's note needs to include, but that's why you're asking an expert, or you're not asking the expert, you're asking the owner to get an expert to say, this person does have a disability. Okay, we talked about reasonable accommodations and modifications. We'll get into some definitions now. So a reasonable accommodation is sitting there and saying, we have this rule. You're not allowed to have more than one pet in a unit, no matter what goes on. And that's the rule. I don't care about the size. I don't care that, they're two tiny little yappy dogs. Doesn't matter. If you have a disability and you have that physician's note that says, yes, John suffers from this disability and John requires, it's a necessity for John to have this emotional support peacock. Well, guess what? You're required to provide that accommodation and give John his emotional support peacock. Okay. An accommodation doesn't include ignoring danger. So there are certain animals, and we'll talk about this later, there are certain animals you don't have to allow in your community, even if they're prescribed. But that's what an accommodation is. It's we have a rule that says X, you're allowed to break that rule, and it's not selective enforcement because you have a medical necessity to break that rule. A modification is a little different. It's a change to the structure or the premises. So putting in one of these pool, the lifts that moves people in a wheelchair up and down so that they can enjoy the pool, that's a modification. We'll get into who's responsible for the expense of that in just a minute. But a person with a disability may need a reasonable modification, a reasonable accommodation, or both to have an equal opportunity to use and enjoy the dwelling and the common areas of the community. So you might require one, you might require both. Keep in mind, you might be required to grant both if both are requested. Keep in mind also, you don't have to just offer this up to anyone that didn't ask for it. Okay, it's unlawful to refuse a reasonable accommodation if it's necessary to have the handicapped person an equal opportunity to use and enjoy the dwelling unit, including common areas. As to assistance animals, the requests are made for a reasonable accommodation of the pet restrictions. Again, once that pet is treated as an emotional support animal or a service animal, they are no longer a pet under Florida or federal law. They are a service or support animal. So that one pet restriction could be overridden by a reasonable accommodation request that says John needs 3 emotional support puppies. Okay. John is allowed to have 4 dogs or 4 pets in his unit because 3 of them are not pets. Reasonable accommodations for assistance animals. The Fair Housing Act doesn't require that an association adopt formal procedures for reasonable accommodation requests. I strongly suggest that you consider doing that anyway. And the one that we prepare here in my office isn't even a policy governing how you need to submit the request because you can't require it in a certain format. What it does is outlines the process that the association should go through so that you don't have to reach out to counsel every single time you want to do one of these, review one of these requests, unless there's something that isn't covered in the back and forth that you're supposed to have within that policy. So again, I think that's something every community association should have, is a policy of here's how we handle this. It's one of 8 policies I think everyone should have, but this is not intended as a blitz of here's the business we can do for you. So we're going to skip the rest. If you want the answers to what else do I think you should have, please feel free to reach out. My email address is right on the screen right now. I think it's right on top of my picture, but I'm not going to go through that stuff in detail because the purpose here is to get you information on the Fair Housing Act and how to deal with it. All right. Having formal procedures can help a disabled person in making a request, and that's why we structure it that way. The association can also make the truth and accuracy of information provided during this request process and the back and forth that can go on as part of the approval or denial process, make that part of the representations made by the tenant under a lease if the lease requires truth and accuracy of other material information, meaning you might be able to actually evict a tenant for lying about an emotional support animal necessity. Now, keep in mind, you can't refuse a request because the person making it didn't follow your procedures. That's why we don't even give clients a specific procedure that's required. And the policy we prepare explicitly says it's not required that you follow this and fill out this form, but it will help the association in expediting a response to your request. Okay, the request, you don't need to put it in a specific format. They're not entitled to one unless they actually ask for it. Okay, the request can be made in any way at any time. Doesn't have to be before you move in. Technically, unfortunately, it doesn't have to be before you're violating these rules. You had an emotional support animal. You're just proving that to the association later. So yes, the association will send out its violation notices as is customary. Hey, you have 2 pets in this unit. You have to get one of them out. You pick which. We don't really care. And the owner responds, or the tenant responds, or someone on their behalf responds saying, well, this is an emotional support animal. I'm allowed to keep both. Okay. Now, the person that needs the accommodation doesn't have to be the person requesting the accommodation. It can be made by anyone on their behalf. They also don't need to use any magic words in making the request. If they say, well, I have anxiety and I'm allowed to keep my dog, that's a request for an accommodation. Whether they say it verbally or in writing doesn't matter. Okay, that is an accommodation request that you need to consider seriously. Whether it's the way you wanted it or not doesn't matter under the Fair Housing Act. It's frustrating, but this is the way the law was written on purpose to benefit people with disabilities. And I get that concept. I just don't love it. Okay, moving on. What type of assistance animal is it? There are 2 different types of assistance animals. So a lot of people equate an assistance animal to a support animal, an emotional support puppy. Okay, that's great. But there are 2 different types. One is a service animal, one is support, and they're very different. Okay, the association needs to ask itself, not the owner, what type of animal this is if an owner requests an accommodation. Okay, under the ADA, a service animal is narrowly defined as a dog or miniature horse. That's not in the slides, but that's the only other type of animal that can be a service animal. It's got to be individually trained to do a specific task for the benefit of the person with the disability, and it needs to be necessary to have the animal perform that task either because it's extremely helpful with the disability or because the owner can't perform that function themselves. Now, this could be a physical, a sensory, a psychiatric, intellectual, or other mental disability that's being served. It doesn't matter what the disability is. It's just that the performance of the work or the tasks is based on training, and the dog or the miniature horse can take specific actions when needed to help this person. Other species are not allowed, other than, like I said, regardless of what they are. Now, it may be a support animal, even though it's not a service animal. So that's why I say, no, it's not something that we reach out to the owner and say, which is it? We evaluate, or the association evaluates based on the information provided, which one it is. And you are allowed to come back and ask certain questions, but not all questions, to get all the information you need to make a decision of which one it is and whether you can allow the accommodation. Okay, that work must be directly related to the individual's disability, meaning, it's not that the dog can go get John a beer. That's great. I would love to have that dog in my house, but that doesn't mean that it serves a disability. Okay, because remember, alcoholism is not considered a disability under these laws. Emotional support, comfort, well-being, and companionship are not work or tasks that animal can be trained for. That's a support animal. That's not a service animal. Okay, so we go through this entire procedure, and this is probably the most valuable piece of what you're going to get today, because you can refer back to it anytime you need to. This is the procedure we go through to determine whether someone can have a service animal. Is it a dog? If yes, proceed to the next question. I will add again, if it's a miniature horse, still proceed to the next question. If the answer is no, it's not a dog or miniature horse, it's not a service animal, and you can move on with your life and say no as a service animal. Is it readily apparent that the dog's trained to do specific work to benefit the disability? If yes, you can't ask any more questions because the animal is a service animal. The owner's entitled to that accommodation. If the answer is no, you keep moving. Okay, readily apparent means it's obvious. Could be guiding someone who's blind, pulling a wheelchair, providing assistance with stability or balance to an individual with an observable mobility disability, someone who's missing a digit, a leg, whatever. So the next question that you're allowed to ask, if you're moving on with the questioning and you're not granting it already, is the animal required because of a disability? If the answer is yes and the task has been identified, you grant the request if it's otherwise reasonable, because the animal is a service animal and you have to. If the answer to this question is no, the animal's not a service animal, but might be another type of animal. Okay, again, it might be an assistance animal, a support animal, but it's not a service animal. So moving on, support animals. This is literally doesn't need to be trained in any way, shape, or form. It's just well, this person helps, or I'm sorry, this animal helps me. It can be normal animals, it can be reptiles, it can be barnyard animals, monkeys, kangaroos. I've actually seen an emotional support peacock, which, as I mentioned before, I'm trying to think of the one that I had a couple weeks ago, but I even posted it on LinkedIn because I was so excited to finally get one. Haven't seen an emotional support alligator, but we're in Florida, so I'm kind of surprised in 17 years we haven't gotten that. But I'm sure anyone that's watching this will make it happen in the near future, just so I can put that one up on LinkedIn as well. So establishing the disability, is it observable and obvious? If the answer is yes, you don't do anything else. They have an observable disability. The need has been established for a support, not necessarily the support that the person's asking for. Okay, the other thing is, did they give enough information to lead you to understand that they're disabled? That's the physician's note that they might provide saying, hey, they're totally disabled. They're missing an ankle or something like that, some crazy stuff I've seen come up. But the more obvious ones are, yes, they are actually blind. That's why they wear sunglasses at night, things like that. Okay, so if the answer to all of this is no, we move on. Again, keep in mind, this is an interactive process. It's not just a yes or no answer most of the time, but if you go through the process that we're giving you, it might be a little bit easier to get to the point of yes or no in the end. And I'm going to skip through some of this information at the bottom because we do not have a ton of time, and I want to make sure that Chuck gets his time and we have time for Q&A at the end. Has the person requesting the accommodation provided information that reasonably supports that they have a disability? If yes, Okay, we move forward. We're not saying no, we're moving forward to deciding whether we're going to allow the accommodation. If they can't prove that they actually have a disability, if you ask for a physician's note and they refuse to provide it, or if the physician's note that they gave is not good enough and you report back and say, hey, this doesn't actually say you have any diagnosed disability whatsoever. It says you're not happy. That's not a disability. Unhappiness is not a disability. You don't have a case of the sad. Okay. Depression is a disability, but unhappiness is not. So it's a matter of determining, has the information that's been provided, is it enough to determine that they have a disability? If the answer is no, you're done. You just say, I'm sorry, but you haven't provided proof that you have a disability. It's not an obvious disability, and we can't just presume that you're entitled to the accommodation you're asking for. Okay. So information about the disability, it can be a determination of disability from some government agency, receipt of disability benefits um, for someone that's under the age where you would normally get that, veterans disability benefits, etc., eligibility for housing assistance or a housing voucher because of a disability. Essentially, this is all government determinations that the person's disabled. You can't make them go back through the entire process that the government made them go through. The determination that someone doesn't qualify as having a disability for purposes of a benefit or other program doesn't mean they don't have a disability for purposes of this. It just means they didn't meet certain statutory criteria. So don't presume just because they didn't meet the needs of a government program that they're not allowed to have this accommodation. Okay, we're going to not go through this entire list of items, but it may be helpful when you have these things come up in the future to see a list of some of the things that actually are treated as disabilities under the Fair Housing Act. Now, after you've established the disability, now you need to establish the disability related need for the animal. Has the person requesting the accommodation provided information that supports that the animal does something that actually helps the disability? If the answer is yes, we move forward to the type of animal. If the answer is no, and the owners or the person that's asking for the accommodation can't or isn't willing to provide enough information for you to determine whether the support is being given by this animal, your answer is no, I'm sorry. If you can't give us that information, we can't give you the accommodation. Now, you can ask for documentation to some extent. Okay, you can get documentation from this person, from a physician, optometrist, or anyone else that is authorized and qualified to diagnose that disability. Okay, if they won't say what kind of disability they have, that might be a little bit different situation that you reach out to counsel to try and figure out, is this letter good enough under the Fair Housing Act? Okay, a relationship or connection between the disability and the animal also needs to be shown, especially when it's not obvious what function that animal is going to provide. Okay, for non-observable disabilities and animals that provide emotional support, you can also ask for information to provide an individualized assessment of the accommodation request. So you can go back and forth. We call that the interactive process. Rather than just say yes or no, you ask for more information. Okay, moving on. And if you need this guidance on documenting an individual's need for assistance in housing, we put the entire title in there. If you Google it, it's the first thing that comes up. And it's basically sort of plain English explanation of what you can and can't do. Frankly, I would rely on your attorney rather than HUD, because a lot of times they will update this stuff without changing the title, and you might find one that's 10 years out of date. Internet documentation is generally not going to be good enough. Run it by your attorney before you reject it. Okay, but if it's from a physician or if it's from a person's general healthcare professional, it's usually going to be enough as long as the content of that letter is enough to prove that they need the accommodation. Okay, keep in mind, anything you get in connection with these accommodation requests is an official record, but you're not producing any of it in response to an individual records inspection request by anyone other than this person that requested the accommodation. Okay, this is personal protected medical information. You are not disclosing any of it. Okay, getting back to the type of animal, Is it a household animal? If yes, okay, generally speaking, you're probably going to grant the request. If the answer is no, the association doesn't need to grant the accommodation except in rare circumstances. So again, before you say no, contact counsel. Okay, you might have unique animals like a literal trained monkey. If someone can't use a dog, that might be a reason to use a different animal. I'm not going to go into detail about all of these individual items, but keep in mind, you might have a lot of different options out there of what type of animals you might need to allow in your community. Now, if an animal poses a direct threat, so for example, you've got an emotional support tiger, Chuck and I discussed earlier today, you might be required to keep the animal in a secure enclosure within your unit and not take it out anywhere else in the community. Okay, that might cause some cleanliness problems. That's on you until it gets to the point where it might impact other lots or units, in which case the association will have the authority to come in and enforce its restrictions on nuisances. Determining that the individual animal poses a direct threat of harm to others needs to be based on an individualized assessment, not just, well, this type of animal we think is dangerous. There needs to either be case law that says the animal is inherently dangerous. Okay, that could be the tiger, the lion, whatever, bear, oh my. But whatever it is, you're dealing with dangerous animals, you can deal with them differently, is really what it comes down to. I mentioned this interactive process. Before you say no, you're required to go back to the owner and ask for more information until you get to the point where doing that would just be a waste of time because they're obviously refusing to provide the information you need. It's at that point that you report back and say, hey, you know what? We can't grant the request without more information. So we're not denying it, but we'll reconsider if you provide that additional information. As of now, we just can't grant it. If you're refusing, you need to consider alternative accommodations. So, I want to have my emotional support tiger in my unit or, walking around. Well, you can't have the support tiger walking around, but you can have it in your unit kept in a cage at all times so that it's not a danger to everyone else. An alternative accommodation is basically, listen, we're going to work with you and try and give you an accommodation that still serves your disability the same way, but it's not going to be what you asked for because we can't provide what you asked for as an accommodation.
And Alan, I think we get into it later, but it's relevant here. An unreasonably long delay in a response could be treated as a denial as well.
Correct. That would be considered the equivalent of a denial if you wait. And I've seen it where even if it's 2 weeks as a delay after you receive the most recent range of information, absolutely, Chuck. Denial is not just saying no. It's you didn't respond saying yes within a reasonable time.
Right. So don't just sit on it. Talk to your expert.
Right. You can't require a deposit for an assistance animal or an extra fee as a condition of receiving a reasonable accommodation, even if it's charged for pets. So I think I've said in the past, not on this webinar, but maybe to you, Chuck, that you can still require the fee. Technically, it's not a pet, it's an animal. So nope,
Right.
not happening. Can't ask an applicant to provide access to medical records or medical providers or a detailed or extensive information or documentation of the disability. It's just they have this disability, not a range of how bad it is or anything like that. Not a definition of the disability or how it impacts the person. Just you have this disability, the person is qualified to diagnose it, and this particular animal is needed to serve the disability. You also can't unreasonably delay, which is what Chuck just mentioned. Okay, where can the animal go? Well, the disabled person's responsible for all of the maintenance, veterinary care, etc., and full control of the animal. So if the person can't control the animal, like if they're missing a leg and this is a tiger, I'm sorry, but they probably can't have that tiger. Okay, the individual may do that on their own or with assistance. The association does need to provide an exception to no pet policies unless it would impose an undue financial and administrative burden to do that, or would fundamentally alter the nature of the housing provided services. It will almost never fundamentally alter the nature of your services as an HOA or a condo to allow an animal in your building. You can also adopt rules governing the conduct of assistance animals. Okay, consult your attorney. The conditions that apply to pets might not apply to assistance animals. So weight, breed, or size restrictions might not apply. The board does have authority to create rules, but it's limited. It's not clear as to whether it's acceptable to create reasonable rules governing assistance animal conduct, like requiring them to pick up the waste or prohibiting presence of the animal within a pool area. Generally speaking, some of these things you actually can't have in your rules. So rather than go through all of this, I will say make sure that if you're adopting rules and applying them to an assistance animal or creating rules specifically for assistance animals, run them by your attorney before you actually adopt those rules. Now, the animal doesn't count toward the number of allowable pets. I mentioned that earlier. And so when you have an alleged violation, the claim can be brought under a couple different places. It can be intentional discrimination, disparate impact, meaning one group is impacted differently than others, even if it wasn't intentional, or failure to allow the reasonable accommodation or modification. All of these can be part of a fair housing claim. These claims are generally brought with administrative agencies such as the Florida Commission on Human Relations or in federal or state court, or they can be brought locally. So they can be brought to any of these places. And keep in mind that any and all of them are subject to that you don't get your fees back restriction. So be very careful when it comes to this stuff because you will have people that are out there looking for reasons to file one of these claims. And you want to be able to argue that it truly was bad faith, that you did everything you possibly could to allow for that accommodation, but they just refused to provide the information you needed. I'm not
And the
going to
statute of limitations is 1 year on that for them to file that from the date of, would it be assuming the date of denial, I guess.
So it's the date of whatever the event was that caused
Right.
them to believe that they had been denied.
There you go.
Alternatively, keep in mind, yes, it's 1 year, I believe, under the Fair Housing Act, but there are other claims that could be brought. There are 2 year statute of limitations. So
Right. That's a good point.
just be careful and make sure. Yeah, you're correct, Chuck, that there are limitations on this. But keep in mind there can be massive penalties. I mean, I've seen, fortunately, none of our clients and none of the clients that I've worked with to protect them a little bit better, but there are penalties. I mean, it's right in this slide, 65 grand for a third violation in 7 years, not to mention the dollars that can be awarded to the owner plus their fees and costs. Sometimes all of that ranges in the 100 to 200,000 range. And it can go, if it's a class action, it can go even higher. So just be very careful. Federal district court, we mentioned, punitive damages can be awarded in these claims. So be very careful. If you really do screw it up, that could be a big problem for the association. And we're going to skip some of this we'll skip one slide to get to Chuck's material. So Chuck, I'll turn it over to you.
Okay. Sorry. And if you could keep your screen share, Alan, I'd appreciate
Sure.
that.
No problem.
So director personal liability can be found. We've got an example of this case, Pope versus Key Colony, where the plaintiffs alleged that every single member of the board was personally involved in all of the acts, and that the board personally intentionally discriminated against families. The board members, of course, filed the motion to dismiss, stating that they were acting on behalf of the corporation and should have no individual liability. However, the court held that the nonprofit statute does not protect against that 617 Florida statutes against willful violations of rights protected by the FHA. Because the immunity doesn't apply to the breach or bad faith, their duties constitute recklessness, they could be held liable for their unlawful conduct. So this stuff is not to be taken lightly. This is not an instance where we would suggest board members just say, "Oh, well, it's not on us. We can say anything we want because they're making an application to the association." So just be careful there. Did I miss anything there, Alan? Or
Oh, you got it.
okay, and then we've got some. Oh yeah, an interesting case, Hahn v. Shoreline Towers. This was in 2005. Mr. Hahn unsuccessfully was denied permission to keep his dog Booster. And at the time, he did not claim that he was physically or psychologically disabled. About a year later, the dog was certified as a service animal. And thereafter, Mr. Hahn claimed for the first time that he was disabled and needed the reasonable accommodation to keep Booster. Mr. Hahn provided a letter stating that for quite some time or a long time, he was the victim of a kidnapping in which he experienced a lot of mental anguish, and which mental anguish required having his assistance animals. So I think that kind of sets up the facts. If you want to go to the next slide, Alan.
Sure.
And he provided a couple of letters. After receiving the first letter, the manager sent Hahn a request for additional information. Mr. Hahn did not respond at all. Just kind of threw out the manager's email or letter and went about his life with his new dog. And thereafter, the general manager wrote another letter and asked for more documentation. How does this impairment substantially limit your life functions? Why is the, as Alan had pointed out earlier, how is Booster necessary to afford him an equal opportunity to use and enjoy his unit? And if there are other corrective measures which we should get into, which will permit such use and enjoyment, we'll get into that actually in an example later if we make it. And Mr. Hahn didn't respond again. He just simply filed a complaint with the FCHR, which is the Florida Commission on Human Relations, as he had a state claim, which we briefly went over earlier. And did he file a lawsuit?
Yep.
With a violation of the FFHA as well. So a violation of federal and state law, and then an infliction of emotional distress count, as well as an injunction. Mr. Hahn attached a couple of letters, one from a psychologist stating that Mr. Hahn was unable to properly cope with anxiety and stress, and he was particularly vulnerable because of his past kidnapping experience. And Dr. Evans further wrote that he was prescribing a service animal to provide support and help Mr. Hahn cope with his crippling disability. It included a brief description of the specific tasks the Booster was able to perform, bringing and removing shoes, opening up the fridge, bringing him a phone, giving hugs to calm him after a panic attack. So these are all, this letter seems, we can go to the next one, seems to have a lot of the elements that you might look for to show that Mr. Hahn has a certifiable disability, okay, or a disability that's evidenced by a medical expert. Next slide, please. The second letter that Mr. Hahn got was from a chiropractor who wrote that he was really familiar with Mr. Hahn's history and that Mr. Hahn had certain limitations regarding his mobility and that the support animal would assist him with his disability. So again, some comments there. We can go to the next one, Alan. From a medical expert, although a chiropractor, I guess, do you have any comment about that, Alan, about the, I guess, quote unquote, levels of medical expertise, whether that comes from, and might see that in another later one, an example where the applicant's best friend, who was also a nurse, wrote a letter on her behalf. I don't know that I'd put as much weight on that, for instance.
Well, and I would go with, unless it's an issue with the function that the doctor or the physician actually serves, to me, they're not qualified, to have a chiropractor talking about neurological damage is probably inappropriate.
Right. And I would also think, that having your best friend who also happens to be a nurse, say that she thinks that you're just super depressed and need this dog may not be the best thing, because it could be a little self-serving is my only point there. So
agreed.
I think and the second comment on this is just pointing that, as it turns out, Mr. Hahn wrote the letters for both of the doctors pretty much and had them sign it.
Probably made some changes. Sure.
Probably, right. He said the good doctor testified that he probably made some changes. So the court made its notes. Chiropractor Hoda made no attempt to explain the purported limitations and disability that Mr. Hahn was experiencing. As Alan had pointed out earlier, the evidence in the form of letters, recommendations, medical notes, needs to show that the person is disabled and what those limitations might be. So, and the record went on to reflect that the chiropractor had only seen Mr. Hahn 2 times. And he conceded a deposition, although he signed it, Hahn wrote the letter, as we indicated before. So next slide, please. Right, and the court concluded that the board did not deny the request, but rather it asked the plaintiff twice. 2 times Mr. Hahn took the manager's letter and threw it in the trash, as we might assume, or just didn't read it. The board did not outright deny Mr. Hahn's request. It gave him a...
Slides will be back in a second. Just continue.
Yep. It gave him a... let me get to my slides here.
I've got them coming up. Just
yep,
give me a sec.
No problem. I've got them here too.
Okay.
It gave him a...
And folks,
allowed him to give a speech in support, okay? And the court found that the lack of information that the manager had, and in light of the fact the plaintiff had previously asked for permission to keep the same dog as a quote-unquote pet, no reasonable juror can conclude that the board knew that Hahn was handicapped when it made the decision to deny his request, right? So it's important. I think one of the things to take from this is to ask the right questions. If you're not getting proper documentation or sufficient documentation, you can request more documentation, but you should, as we have pointed out a number of times, also consult with your expert throughout so that you're not delaying and not responding, so that a lawsuit like this one Mr. Hahn dropped on the association out of nowhere with no communication. And as I would probably think that most of you on this webinar know or have experienced in the past, unit owners and owners are not always great communicators. And I think that might be the understatement of the year, but I digress. And so just, another thing to think about as you are evaluating any of these requests. So
Chuck, which page are you on right now?
we are on 60 now.
Okay.
So now we're on Sun Harbor and Bonnera. This is the one that I was referring to that had the Mr. and Mrs. So Mrs. Bonnera, Mr. Bonnera's fiance had a dog, and there was a no dog policy in the community. Letters were sent by his fiance that three medical professionals testified at trial in support of the claim that the fiance should receive a reasonable accommodation for her quote unquote therapy dog. Next slide, please. So we have a medical doctor's testimony, a psychiatrist's testimony, as well as the nurse and personal friend, all who found that she had ongoing depression and anxiety, /severe depression and anxiety. And I think probably that that lessened with her interaction with her dog, which may be an important point. Okay, next slide, please. So the court determined that the letters were insufficient and provided unclear explanations as to the nature and extent of the fiance's disability, such that Sun Harbor could not conduct a meaningful review, and that the testimony from the medical professionals did not provide competent and substantial evidence indicating any substantial limitation on one or more of the fiance's major life activities. And it failed to establish the necessity of the accommodation. So as you'll see in 2, the court seems to suggest that a letter saying how his fiance is qualified, the limitations and difficulties she was suffering from, why she is entitled to the dog, or that the dog had occupied the residence was necessary to afford her equal opportunity to use and enjoy a dwelling, would be sufficient evidence to require reasonable accommodation for assistance animal. So her letters were also lacking substance. Next slide, please. Okay. Then the last case that we wanted to point out as just is good real life example is McKay v. South Seas East Condo Apartment of Marco Island. And Mr. McKay, unit owner, was alleged that he was handicapped with physical impairments, which substantially limit his ability to walk and maintain his balance. And that due to such handicap, he requires the assistance of a service animal. Mr. McKay made his initial request to have an assistance animal reside with him. The association requested additional info related to his request. In response to the request, Mr. McKay provided the association's request for medical records was overbroad and in excess of what was necessary to make a determination. And then the association then acknowledged that the qualifications of the animal were not an issue, but reissued their request for medical information. Next slide, please. So Mr. McKay went ahead and delivered a doctor's letter to the association that provided that he required the use of an assistance animal because it helped him with balancing to prevent his falls, or getting up after a fall to use him as a kind of a balance, and guiding him, turning off and on lights. And a second letter was also sent by the doctor, which additionally provided that no other assistance device such as a cane or walker could provide the same assistance to McKay. So really it was only the dog. So the court determined that Mr. McKay could keep his dog as a assistance animal because he's sufficiently established that he's handicapped for those purposes. And it was necessary to afford him the opportunity to get around his unit, basically. Okay. So I think those are some good examples. And we have some real life, I don't know that we have time though, Alan, but we have some case studies, but
We do have some
I think
time.
yeah, but however you want to go. So that was the third case we wanted to mention and run through.
Well, I'll mention before you guys go over anything else, we know the advertised time is here. So folks, I know some of you have other issues and need to head out. So we already placed the evaluation link in the chat. The required part ends after you click on that link and fill out the evaluation. All right, so go ahead and do that. Then you can head out if you need to. The Q&A, you're welcome to hang out for that too. But again, after you have listened to the presentation and fill out your evaluation, the required part is over and you can head out if you need to. Back to you guys.
Great, thanks, Jeff. Do we want to go to Q&A, Alan, or
Sure. We can do that.
let's see what we got?
Courtney, do you want to jump in and read off, or do you want us to just take care of it? It's up to you.
Whatever you guys prefer. I don't mind reading.
Okay.
But I'll read a couple and then we'll go.
Okay. When you get
Okay.
tired of it, we'll take over.
Okay. So I'm gonna start from the top. There's a couple people that did multiple, so to be fair, I'm gonna do one for each person. All right. So Paulina, I think that's how you say your name. I apologize. Asks, is failing to provide a disability parking spot to a person with a physical disability if the HOA has no more available spots on the premises, all are taken, a violation?
So this is a tough one. You might actually have to swap someone's spot out so that a spot that's closer, you may not be able to give an actual disabled spot, but if the spots are assigned, you may have to swap someone's spot and give them one that's farther away because this person has the need. Now, I've seen cases go both ways where, the association said no and won, or the association said no and lost. The question is, do you really want to risk that you're going to spend 50 grand on both sides, pay your attorney, pay the other side's attorney, which, by the way, you may or may not be covered for this under your insurance policy. So it might be wise to reach out to your insurance carrier and find that information out after today's class. But the uncertainty, in my opinion, and the risk that you're sitting there with what could be, 50,000 in damages, 50,000 in their fees, 50,000 in your fees, rather than trying to make it work. I don't know which risk you want to take. Is it the risk that the owner who you're moving out of their space is going to sue you because they had that space, it's theirs? Or is it that the person who actually has a handicap is going to sue you because you didn't give the accommodation that they needed? Sometimes you can work out an actual accommodation with the owner who you're asking to swap spaces. Sometimes you can't. So it's usually the best way to do it from my perspective is if you can reach a mutually agreeable situation and the owner who's losing their better space, so to speak, is willing to accept something else, a better XYZ, use of some kind of amenity when they normally wouldn't be able to, or something like that. That's usually the best way to deal with it, but that's the creative mediator side of me, not the attorney side, trying to kind of come out for a little bit.
All right. Thomas asks, is there any way to determine if the FHA law is being abused where folks go out and get a physician's agreement to support an ESA in a non-pet condo association?
So the only thing you're really able to do there is go back and forth with the owner to try and get enough good information that you are able to rely on the opinion of the physician that's giving it. If they happen to pay their physician, I don't know how you would prove that is the issue. So to answer the question, unless you can prove that the physician's being basically paid off to say this person needs an emotional support animal, no, there's not really much you can do. If the opinion that they got is not reliable for some reason because you have a specific reason to question the facts that are stated in the opinion, yeah, maybe you challenge it. But challenging the opinion is basically the most you can do. Now, we didn't mention it, but there's also Florida law on point now where if someone is actually falsifying those records or is getting an opinion that's not accurate as to whether they need this, this emotional support animal, which is what an ESA is, um, there might be criminal prosecution against the person that fabricated the information. But that doesn't necessarily help the association. It's a penalty, but it's not something that actually helps the association get out of this situation.
Okay. Let me move around a little bit. Peter asks if a support animal is of a dangerous type, such as an aggressive dog, what can the association request to protect the other residents?
Chuck, we kind of covered this. Do you want to?
Yeah, I covered this one earlier. A dangerous animal, if it's determined to be that, the association can put together requirements that that service animal has to be caged or enclosed in the unit and may not go onto any areas if it's going to be a danger to the other residents. That would fall under I would think even a general safety issue under the governing documents of the law too. So
Agreed. Yeah, I mean you would basically limit the animal to where it can be. Now keep in mind, it's not just, well, we think this is a dangerous breed. It's either we've seen that this animal is dangerous or it's a dangerous type of animal.
Right.
If it's a dog and it happens to be a pit bull, sorry, but that's not going to be good enough to require someone to keep the pit bull in a cage inside their unit. If you're talking about, like I said earlier, an emotional support tiger, that's staying in the unit in a cage and not getting out.
Okay. Changing gears a little bit, Deborah asks, when you say, as I heard it, that a diagnosis of anxiety is enough to constitute a disability, doesn't it have to be an impairment that substantially limits a major life activity? Does the doctor's note need to address that the substantial limitation of one or more major life activity is?
It should, but a lot of them, it's obvious that it will automatically impact those life activities. Again, yes, to answer the question, if the diagnosis is anxiety, that might be one where you do need to ask for the level, or you might need to ask whether, as a fact, as a diagnosis, we need another note from your physician clarifying whether this actually impacts one or more major life activities. So you can come back through that interactive process that we mentioned and actually ask for information if it's necessary to determine whether that accommodation is actually necessary. And that would be one of the things that you can ask. We're not asking for the level of anxiety. We're not asking whether whether they're smoking weed every night to feel better about life. We're asking, hey, is this something that impacts one or more major life activities? And if the physician comes back and writes a letter that literally says nothing other than the anxiety impacts one or more major life activities, your questioning is done.
Okay. Patricia asks, we have a tenant in a unit in our community. Actually, I'll read this. Sorry, I didn't want to be too community specific. We have a tenant in a unit in our community that has 2 emotional support animals. When one of these assist animals saw another resident with 2 emotional assist animals, his larger dog, approximately 80 pounds, got loose from the owner and attacked one of the other dogs and caused a bleeding wound. In addition, he lost control of the second dog and attacked the owner that was injured. Can we not renew his lease with this tenant? What do we do?
Personally, I would address the animals, not the tenant himself. I mean, you would direct the demand letters to the tenant and to the owner of that unit, but you wouldn't be directly attacking the individual tenant because they had this issue. Unless it's gotten to the point where you really can't allow them to reside there anymore because they won't do anything about it. The other thing is, and this isn't the subject of this class, but you have to have leasing restrictions that actually allow you to deny that tenancy for a specific reason. You could include a dog bite or, a violent incident, whether it's the individual or someone or an animal that's affiliated with the tenant, as a rational basis to deny that tenancy. But you would have to have those rules in place in order to deny it on that basis.
Okay, I'm gonna ask, I'll do one, just let me know when you guys want to stop.
Okay.
Why can't you ask for a training certificate for a service animal to validate the animal is in fact trained for one or more tasks?
You might be able to do that. It just depends on what information you've been given to date and whether it actually supports that the animal's trained. You can ask for a training certificate if the owner has said, this animal's trained to do X. You can ask for proof of that. But if they've already given you documentation that doesn't have to be a training certificate that demonstrates that that animal is actually trained to perform a specific function, that's all that you're allowed to ask for. So it doesn't need to be in any particular form is the point.
Okay. I'll ask a couple more. Valerie asks, what can an HOA do if the ESA causes a nuisance, like a rooster? Roosters crowing starting at 2 a.m. and crows throughout the day, every day. Can this be considered a threat of the ESA, even though it isn't a physical but mental?
So the problem is a nuisance is the hardest thing to prove in court and actually succeed when you're trying to get an injunction. You can ask the owner of that animal to stop, but it's going to be tough to get the animal out on the basis of a nuisance. You would have to really have multiple reports from other owners and record the crowing or the noises being made at 2 in the morning, etc. I'm not saying no, but I will say it's going to be difficult to get that animal out. It might be worth pursuing if it really is a major issue for the community. I will also point something out that we mention usually in our covenant enforcement class and not here, but that sounds more like an owner to owner issue than a community wide problem. And that might be something that you just have your attorney write back to this individual that it's not something that the association intends to take action on, because you're not going to spend association money to go after a single owner who's impacting another single owner. Now, under the Fair Housing Act, if there is discrimination, that is one of those things that you will have to go after an individual, even though they only attacked one other owner, whether verbally or physically. So I don't want you thinking just because it's in between 2 owners within the community or 2 lots or units within the community that you don't have to do anything about it. And in this class in particular, you know, we talk about all these fair housing issues. Any discrimination is something that the association does have an obligation to address. If it impacts more than one unit, it's something the association is obligated to address because it's a matter of common interest. All I'm saying is if it's something like that and it only impacts one neighbor, you're probably going to write back and say, I'm sorry, but you do have the right to enforce the declaration yourself. We don't intend to spend the time or the money to pursue this claim, which is really your claim on your behalf.
Okay. Are you good with answering a few more? It's your guys' time. So we've answered a lot and we're past the 3:10.
Let's take two more.
Okay.
And I'm going to shut up and give him to Chuck unless he needs a little bit of clarification.
Okay.
I'll do my best.
All right.
This one I think is pretty easy. How do we handle an owner who states we cannot ask for documents verifying his dog is a ESA?
I guess I'm not under,
So an owner, so I guess the association is asking an owner for documents verifying that they have an emotional support animal, and that person saying, you cannot ask for those documents. I don't have to give you those documents.
yeah, that's not right. I mean, and it's not really about the animal, it's about the person's disability, right? It could be, when we're talking about emotional support animals, remember service animals is dog and once in a while a mini horse, which I love because I love animals, but the emotional support animal can be really any animal, but the applicant, the owner, the person with the disability needs to prove why that animal, right, assists with that emotional instability. That's probably not the right word. The emotional issue that person's having. So it's not that the animal, they need to provide documentation on the animal. It's that they need to provide documentation on their disability and why that's necessary for that specific animal.
Yeah, I mean, from my perspective, it's a letter from counsel saying why you're wrong, what law says that we're allowed to ask for this information, and that we cannot, as I mentioned earlier, grant that accommodation without information supporting the need for the accommodation you're requesting, and then leave it at that. If the owner comes back and starts yelling, they file a complaint. Here's the letter that we sent saying we're just asking for the information we need to provide the accommodation. This person refused to provide it.
Okay.
So the short answer is the answer to the question that the owner is, you know, saying you can't do this. The answer is you're wrong.
Okay, good. And then the last one from John, if an owner secretly brings an animal into a building, mostly a cat or a bird or fish, into a building as a pet, what risks do we have if no other owner reports the animal, or after several years, you discover the animal?
Well, I guess it would depend on what rules you have with regard to animals in that specific community. For all we know, any animal could be permitted under their rules. So I guess the answer to that question will be, unfortunately, is the the least favorite answer of everyone. Is the attorney answer of that it depends on your governing documents, I think.
I think that question more so meant like they got away with having the animal for so long,
Okay.
and then they found the animal. I think they're asking like, can we still do something if the
I
guy's
see.
like, hey, I've had it for 5 years and you guys never said anything, kind
Well,
of thing.
there is a statute of limitations on enforcing a violation, but that would generally be stayed if there's no way you could have known that the violation was in place. So, you know, I would present the argument there's no way we could have known it wasn't a problem, and the issue that we're pursuing a violation for is not a problem with your animal, it's that you're not allowed to have it and you're doing it anyway. So to the extent that you claim that you have some kind of entitlement to have that animal, it's time for you to prove that up.
Gotcha. Well, thank you so much, guys. That was great. I think we got through a lot of questions. I tried to choose ones that a lot of people ask, like like something very similar. So I think that was awesome. Big thank you, Chuck. It was nice meeting you.
Nice to meet you too. Thank you everyone for your time.
Happy to have you on board at K Bender, and hopefully we'll do future webinars.
Absolutely.
And Alan, as always, you always do a great job presenting and
Always.
Thank you.
questions. So thanks, guys.